Thank you again, everyone, for coming, and welcome to panel 4, examining Earl Dickerson as a community and national leader. I'm Atinuke, Adediran, the David and Pamela Donohue Assistant Professor of Law at Boston College and a former Dickerson Fellow at the University of Chicago Law School. We are fortunate to have two incredible speakers here, Professors Dylan Penningroth and Christopher Schmidt, to help us address this topic. I'm particularly intrigued by the topic because in my own work, I look at contemporary institutions that exclude members of the community who are often racial and ethnic minorities from leadership and decision-making. Earl Dickerson is an iconic example of what it means to push against forces of institutional exclusion, as we've heard from other speakers today, and we hear from both of the speakers as well. Professor Dylan Penningroth is a professor of law and history at the University of California, Berkeley. He's an expert on African-American history and US socio-legal history. His book, The Claims of Kinfolk, African-American Property and Community in the 19th Century, won the Avery Craven Prize from the Organization of American Historians. He has also written on African-Americans' encounter with the law from the Civil War to the modern civil rights movement and legacies of slavery in colonial Ghana. Professor Chris Schmidt is the professor of law and associate dean for faculty development at Chicago Kent College of Law and research professor at the American Bar Foundation. He is the author of the book, Sit-ins, Protests, and Legal Change in the Civil Rights Era. He is currently working on a new book project called Civil Rights in America, A History, which examines how Americans have struggled over the meaning of civil rights from the Civil War until the present. We're so thrilled to have both of them here today. As we've done with other sessions, our speakers will each speak for about 20 to 25 minutes. Then we'll open up the discussion for Q&A. To ask questions, you can either use the raise hand function on the screen or type your question into the chat and send to me, Atinuke Adediran, either during or after the speakers have spoken. So let's get started. First, we'll start with Professor Penningroth, and then Professor Schmidt will speak next.
Great, thank you. Can you all hear me okay? Great. I'm going to try and share screens. Can you see my slides? Great. Okay, well, first of all, thank you to Professor Adediran and Deans McAdams, Hubbard, and Miles, and thanks to all of you for coming. I just want to start off with a little sort of vignette about Earl Dickerson. In particular, I want to talk about a time when he made a bad move. 1939, Earl Dickerson took on one of the biggest power brokers in Chicago. Dickerson had just been elected an alderman. The man on the right, Clarence Cobbs, was pastor of the First Church of Deliverance, which is a huge church with at least 2,000 members at the time. Now, Cobbs had a weekly radio sermon. He was also on the executive committee of the Chicago NAACP. City leaders attended his annual banquets because they knew that he could deliver the vote. Cobb's church welcomed gay people, and Cobbs himself was widely rumored to be gay. As one activist later put it, he didn't deny it and made no apologies for it. Now, like many other Black gay men and women at the time, his life was veiled yet open. In 1939, the city's leading Black newspaper, the Chicago Defender, reported that Cobbs, and I'll quote, was connected with rumors of an unsavory incident so scandalous, end quote, that the Chicago Crime Commission and the Illinois State's Attorney had both launched official investigations. Cobbs sued the Defender for $250,000. Earl Dickerson represented the Defender on appeal, and he lost. Now, they settled out of court. Apparently, there were no hard feelings. Here they are at a banquet many years later, getting Chicago's Best Dressed Men award. Was Cobbs versus Defender a civil rights case? If civil rights is protection from discrimination on the basis of race, color, religion, or sex, as defined by federal statutes and the US Constitution, then Cobbs doesn't seem to fit. A more classic civil rights case would be something like Hansberry versus Lee, which Dickerson handed at virtually the same time. I'm going to argue that from the 1860s through the 1960s, for most Black people, most of the time, civil rights were not about racial discrimination or exclusion, and they didn't have very much to do with federal law. Civil rights were the rights of property, contract, the right to sue and testify in a court, to go to law, as another Black minister put it in the 1860s. They were rights of everyday use. And for Black lawyers like Dickerson, they were bread and butter practice. This long tradition of Black legal thought and legal activity has passed almost unremarked because I think it defies some of the basic organizing assumptions of the historiography of civil rights. That historiography has tended to conceptualize Black people's relationship to law in much the way that movement activists did in the mid-20th century. That is to say, around the twin axes of race and federal law. Now, over the past 15 years, a debate about periodization and geography has prompted some scholars to ponder anew what we're talking about when we talk about civil rights. So one influential school of thought, often dubbed the long civil rights movement paradigm, holds that the mass protests between the Brown decision of 1954 and the landmark Civil Rights and Voting Rights Acts of the mid-1960s were just the classical phase of a much bigger struggle for full citizenship, radical democracy, and economic justice. Intent on turning the spotlight away from the NAACP, Congress, and the Supreme Court toward a bottom-up, and I'm quoting here, grassroots perspective, long movement scholars have tended to treat law as a submerged form of politics, or dismissed it as, Ken Mack puts it, epiphenomenal, or even irrelevant, or antagonistic to the interests of ordinary people. Other scholars warn that this long civil rights movement paradigm overlooks the distinctiveness of the 1950s and 60s, especially its emphasis on law. My co-panelist Chris Schmidt has shown that it was only after World War II, when the federal government started to tackle Jim Crow, that activists seized on this term civil rights as a label to advance the cause of racial justice. Indeed, because the term emerged from American law rather than from Black culture, Schmidt points out, many other activists considered it to be too legalistic, top-down, and narrow for what they knew to be a larger struggle for Black freedom. In fact, the problem goes beyond periodization or geography. It's also conceptual. The long movement scholars and their critics have tended to tilt attention toward areas of Black life where federal law and social movements made a difference. Voting, the workplace, schools, housing, criminal justice, the military, and public accommodations. And they have tended to extend an older view that state and local law functioned as tools of social control rather than areas of contestation or possibility. Because African Americans were afraid to go to the courthouse to vote, many scholars have assumed that they were afraid to go to the courthouse for anything else. And even as a wave of bottom-up legal history has brought law back into the long movement paradigm, the field remains resolutely centered around racial justice, federal law, and a theory of legal consciousness that carefully distinguishes lay claims from legal claims. Meanwhile, defining civil rights as a matter of racial justice has tended to conflate the non-discrimination principle with the substantive rights that African Americans regularly exercised, even in the South. Caught between their conviction that the real story of civil rights is the struggle to realize the promise of the Reconstruction Constitution of 1865 to 70, and their determination to elevate the perspectives of everyday, grassroots, local people, scholars have tended to portray those everyday people's ideas of rights in vague, symbolic, almost anti-legalist terms, as cultural or political rhetoric rather than as legal claims. It's been easier to imagine Black people fighting for freedom or justice or full citizenship than to imagine them arguing over alimony or a deed of trust. Historians now speak of a freedom struggle and put ordinary Black people at the heart of it. But often, it seems, Black people are seen as ordinary precisely because they knew so little about rights. In fact, by the 1950s, generations of Black people had been using and talking about rights in quite specific legal terms. It's just that the rights they used the most didn't have much to do with federal law or racial justice. This talk is part of a larger project that describes how the modern meaning of civil rights displaced the one that's familiar to 19th century historians, and how it hid Black people's long engagement with legal rules, legal ideas, and legal institutions. And today I'm going to focus on the Black lawyers of Earl Dickerson's generation as just one strand of that engagement. And I'm going to build on recent work by Schmidt and Kenneth Mack and Tamika Brown-Nagin and some others. I'm going to argue that the revival of Black lawyers' professional fortunes after the 1930s was fueled by state common law claims, Black people exercising the rights of everyday use. And yet their very success helped carve out civil rights as a legal field distinct from the rights of everyday use, cast in anti-discrimination principles and aimed at federal law. So let me start by sketching what Black legal activity looked like during Earl Dickerson's lifetime. And I'm here going to talk based on my research in county and county circuit courts. Dickerson was born in Madison County, Mississippi in 1891. When he was 1 year old, 1 out of every 10 civil plaintiffs in the Mississippi part of my sample was African American. In 1922, when he graduated from University of Chicago Law School, Black people filed 12 of a sampled 122 civil suits in the Cook County Court, and 39 out of 189 of my sample of the Mississippi County Circuit Courts. In 1942, just after he argued Hansberry versus Lee, 14 of my sample plaintiffs who lodged suits in civil suits in Cook County Circuit Court were Black. You get the idea. Now, most of these suits were against other Black people. And to me, that indicates that private law did not, on its own, address racial inequality. But look at the diversity of the things they were suing about. They used the courts for all kinds of things. They sued for divorce. They sued over car accidents, farms, unpaid rent, insurance money. They swore out warrants to get satisfaction from white neighbors who assaulted them, from town officials who damaged their property. And they sued other Black people to hush up a daughter's out-of-wedlock pregnancy. They exercised their civil rights out of court in routine ways too. So they sold easements on their land, made out wills and got them probated. They bought, sold, and gifted land. In other words, during a century when the US Constitution's guarantees of equal protection and due process remained empty promises, African Americans routinely exercised state civil rights of property, contract, and standing. And although people rarely referred to them explicitly as civil rights, that is what they were. Now, as Ken Mack has shown, these rights of everyday use were bread and butter practice for Earl Dickerson and for most Black lawyers. Even for those who were getting famous for the anti-discrimination litigation by the 1940s and 50s, like Thurgood Marshall and Alien Higginbotham, they had spent their early careers garnishing workers' paychecks or dealing with small property matters, and I'm quoting Ken here, little two-for-nothing misdemeanor cases, selling insurance and real estate on the side, taking everything that walked through the door, trying to land a big client like a laundry business or a church. And so most Black lawyers in the 40s, 50s, and 60s still thought of themselves as general practitioners with a traditional bread and butter practice, a neighborhood practice. And for them, the NAACP's headline-grabbing victories were publicity for cashing in, among other things. They were a decades-long demonstration of competence that would finally unlock the gates of prejudice and convince Black people of the competence of Black attorneys. In this, they weren't so different from white lawyers who often did free work for clubs and charities as, quote, a form of advertising, end quote. For many Black lawyers, what made the 60s seem like a turning point was that they finally had the professional freedom that came with better incomes, more freedom to choose the cases they wanted and to fight them how they wanted. One of them recalled it this way: that's why they couldn't buffalo the new breed of Black lawyers. Johnny Cochran didn't need the money, so he could go ahead with the cases he felt were worthwhile, end quote, whether or not they counted as civil rights. Now, this tremendous variation in caseload, combined with the diverse ideas about race work that were circulating among Black professionals, fostered an ecumenical sense of what civil rights could be well into the 1950s. Because Black lawyers had developed their assumptions about civil rights before there was a toolshed of public law remedies to resort to, their conception of civil rights drew deeply from all their practice areas, especially the routine private law matters that took up most of their time. You can see the seamlessness of the small firm Black lawyers' civil rights vision even in their file cabinets. Sadie Alexander scribbled notes on a domestic assault case on the back of a Xerox statement titled "Statement on Khrushchev Visit," and a draft affidavit for a will on the back of a typed schedule for UN Week. Her law partner and her husband, Raymond Alexander, filed his copy of the briefs in Brown versus Board of Education between divorce papers that he was handling for women named Loretta Brown and Pearl Logan Brown. The office was busy. You grabbed a piece of paper, you wrote on the back. You filed things in alphabetical order. Oliver Brown's case went under the B's. And so bread and butter neighborhood practice subtly shaped Black lawyers' approach to the great equal protection cases of the 1940s and 50s. For example, the NAACP lawyers intended the school desegregation cases to do more than strike down the Plessy Doctrine. According to William Hastie, they also meant the cases to, quote, teach and lead within the communities where the cases were being argued. Well, what lesson did they think that they were teaching? That the public laws mandating racial segregation could be described and attacked in the language of private law. In fact, it was Thurgood Marshall's intuition that public and private harms were related that led the NAACP team to incorporate ideas from social psychology, what came to be known as the Dahl tests. Years later, Marshall sat down with Richard Kluger and described the Brown team's brainstorming about the so-called social science approach. And this is what he said. I said that we had to try this case just like any other case with damages. If your car ran over me, you'd have to pay up. And my job as a lawyer would be to put experts on the stand to testify how much damage was done. I thought the Dahl test was a way of showing injury to these youngsters. And despite the hail of criticism that pelted the court's famous footnote 11 with its reference to Mamie and Kenneth Clark's psychological experiments, Marshall in 1973 was still insisting he wasn't at all leery. Quote, he said he had wanted all this kind of evidence on the record. He wanted it there because Black people in Topeka and Somerton, South Carolina, knew perfectly well what a personal injury suit was. For him, the psychologists were just the handiest way to prove a tort, like x-rays for a car crash victim, a tangible injury that had an obvious legal remedy. But there was no room for Marshall's tort plaintiff in the story of simple justice that people started telling in the 1970s. As civil rights became more tightly linked to race discrimination and more intensely charged with universal moral values such as injustice, freedom, and dignity, the term pulled still further away from rights of everyday use, the rights most Black lawyers actually depended on for a living. Professor Thaxton introduced us this morning to Elisha Scott, who filed the original suit against the Topeka School Board. Now, Scott made his bread and butter from oil and gas cases. His clients were Black Texans, Oklahomans, and Kansas who had land, swampy lands. Oil got discovered on them, and suddenly they were beset by oil company agents and jealous whites. He was a gifted litigator. His secretary recalled that he could, quote, make a jury cry like a Baptist minister, end quote. Another person said that he could, quote, dictate a deed from memory with all the whereases. So Scott was the obvious choice when activists began trying to desegregate the Kansas schools. In both his private cases, and this is a quote, his private cases and his NAACP work, Elisha Scott worked to, as his secretary put it, protect Blacks. And yet a case like Brown made some of the habits and practices of private cases look crass. So to a white Kansan who helped organize the Brown litigation, Scott's courtroom oratory sounded like the, quote, unorganized flair of a typical South Midwestern Negro lawyer, end quote. Even worse, this person said, he was always needing $20 for a brief or $50 for a deposition, which surprised me, since I just assumed a Negro attorney would work for a civil rights case for nothing, end quote. And that was something that many Black people believed too. The NAACP built its campaign on the skills of local Black lawyers like Elisha Scott, but that campaign forced it to invent a new model for financing and litigating lawsuits, one that would soon have no room for a lawyer who looked and sounded like Scott. The problem was that most Black lawyers sounded a bit like Scott, at least sometimes, because they couldn't afford to give away their services for free. Unlike Earl Dickerson, they didn't have supreme life insurance behind them. Black lawyers out in the NAACP branches had been bickering with the national office for years over fees. And in 1959, Fred Shuttlesworth went and accused the local attorneys who were handling Birmingham's desegregation lawsuits of trying to, quote, milk big money out of the sacred struggle for first-class citizenship, end quote. The moralizing universals of civil rights rhetoric, the appeal to constitutional principles, the presumption that lawyers handled civil rights cases for nothing, combined to carve out civil rights as a distinct, though somewhat unstable legal category. For Black lawyers, the presumption that civil rights was a sacred struggle for racial justice opened up something deeper than awkwardness about fees and crass behavior. If the demands of financing and oratory and the oratory of racial justice helped mark out the boundaries of a modern concept of civil rights, the passage of the great civil rights statutes of the late 1960s helped crystallize it. The universalizing moral values were encoded in the legislation itself, as floor debates echoed Martin Luther King Jr.'s wrenching description of 6-year-old children humiliated by the Jim Crow system. The higher that civil rights floated into the realm of the sacred, the more awkward it became for the lawyers who actually handled these cases. As Robert Carter, who helped argue the Brown case, pointed out, the typical civil rights lawsuit brought all the enormous expense and headache of a complex trial without any of its payoff. After all, the plaintiffs were usually asking for an injunction, not damages. They wanted a decree to open the schoolhouse door, not a pile of money. Because civil rights suits rarely paid much, lawyers didn't compete to get them. Instead, smaller firms and solo practitioners often handed them off to one of the NAACP LDF's local cooperating attorneys so that they could concentrate on bill-paying matters such as negligence and workman's comp, property, and probate. Or they divided up the work in-house, as Richmond's Hill, Tucker, and Marsh firm did in the 1960s and 70s. Henry Marsh, he told me later, handled the civil rights suits, he called them that. Oliver Hill focused on NAACP matters, and S.W. Tucker specialized in partition suits. Tucker loved wrestling with them, Marsh recalled. The family trees, the percentages, and all that, nobody else liked them. The very words that survey researchers now used to describe Black lawyers' work, bread and butter practice, constitutional law, and/or civil rights, suggests that partition suits somehow didn't count as civil rights anymore, at least not unless it looked like a matter of racial injustice. And yet the older meanings, where ideas of race uplift and common law rights fused with anti-discrimination and anti-humiliation, didn't completely vanish. And this was partly because in writing the super statutes of the 1960s, Congress once again chose not to replace wholesale the 50 states' vast corpus of property, contract, and tort law. Instead, what Congress did was install discrimination as a latchkey to the federal courts. Let's go back to Hill, Tucker, and Marsh for a minute. Oliver Hill said years later that in the 1970s, he spotted an opportunity for Black lawyers in the growing field of torts, but he realized that he was, quote, too busy fighting segregation to take it up himself, end quote. He had heard that George Allen, a white lawyer, was developing a new theory for trying negligence cases. And he remembered that they had actually met back in 1930 during an eviction suit. So he invited George Allen to workshop his negligence theory for the members of Virginia's Black Bar Association. The quiet harmony between anti-discrimination work and other kinds of lawyering resounds even more clearly in one of Henry Marsh's rare church suits. Now, of course, these were always intra-racial. They were governed by church rules and by state law. Marsh's client had been summarily disciplined by the trustees of one of Richmond, Virginia's Black Baptist churches. And he sued to force the trustees to give him a regular church trial. The judge ruled that this man, Marsh's client, was entitled to a trial. And when the judge did that, Marsh could barely keep a straight face. Around that time, during the 1970s, Marsh had been spearheading a series of employment discrimination cases in Richmond. He recalled those cases this way: "We sued everybody, from Philip Morris to DuPont, and he had been winning back pay settlements, including for many members of this church. All those employment discrimination suits had engendered a fleeting sense among Black Richmonders that, as he put it, we were all together. And that is why he knew his client would win his court-ordered church trial, which had nothing to do with racial injustice, in a landslide." Marsh was still chuckling about the church trustees blundering 40 years later. Quote, "Those people were dumb enough to get a white lawyer against me in my heyday?" The stunning achievements of Houston and Marshall's litigation strategy has made it easy to forget that whatever else it was, a cause, a calling, a tool for forcing social change, for most Black lawyers, most of the time, law was a way to make a living. And as Black lawyers remade their professional identities during the 1950s and 60s, marking out anti-discrimination law and later affirmative action law as a distinct, morally charged, almost sacred field of practice, they nevertheless preserved and sometimes still drew from the idea that civil rights were rights of everyday use. Thanks.
Thank you so much, Professor Penningroth. Now we're going to have Professor Schmidt speak.
All right, thank you so much, Tino. Thank you, Richard, William, Sharon, and everyone else who has a role in making this wonderful event happen. Thank you in particular to the organizers for letting me share the virtual stage with my dear friend, Dylan Penningroth, to get to hear his latest work. This is fantastic, so thank you for that too. I also have some slides, so let me pull up a share screen and then I'll get going with my presentation. Everyone see that? In 1951, Earl Dickerson was elected president of the National Lawyers Guild, a group formed in 1937 as a progressive, racially integrated alternative to the American Bar Association. Dickerson was the first African-American to head a predominantly white bar association. The years in which he led the Guild, 1951 to 1954, were particularly challenging ones for the organization, as the Guild was one of the targets of the anti-communist fervor that spread across the nation. Much of Dickerson's tenure was spent fending off Justice Department efforts to include the Guild on its list of subversive organizations. In my remarks today, I'm going to explore the challenges as well as the opportunities that proponents of racial equality face during a period of history in which the nation's political culture often translated demands for social change into acts of disloyalty. The early Cold War years marginalized many of the progressives and radicals who had led the struggle for racial equality in the preceding decades. Yet the same period also saw a growing acceptance in mainstream American society and politics for anti-discrimination and desegregation policies. In language that first emerged during this period, the cause of civil rights, meaning promoting racial equality through legal reform, was running on a different track from the cause of civil liberties, meaning protecting individual rights against abusive use of government power. When Dickerson took the lead of the National Lawyers Guild in 1951, he assumed a leading role in a campaign to advance both civil rights and civil liberties. This is a path different from the one chosen by many other leading African-American activists of the day. The leaders of the NAACP's national office, including Walter White and Thurgood Marshall, adopted an aggressive anti-communist line, expelling Communist Party members from the organization and condemning Jim Crow as a threat to the nation's Cold War foreign policy interests. In effect, they chose to distance themselves from progressive battles over civil liberties so they could more effectively advance their agenda for civil rights. I look at Dickerson's tenure as the head of the Guild to explore the challenges social justice activists faced in navigating the civil rights, civil liberties divide during the early years of the Cold War. I'm going to organize my comments as follows. First, I'm going to offer a brief overview of the National Lawyers Guild, why it was formed, what it did, and why it was so controversial during Dickerson's tenure as its president. Then I'll describe the emergence in the years following World War II of the idea of a civil rights, civil liberties distinction. I consider how this linguistic innovation reflected and reinforced developments in the political and social reform activist spheres, with a particular focus on how this emergent civil rights, civil liberties divide created new opportunities for certain kinds of reform efforts while it constrained others. I then placed Earl Dickerson's experience with the National Lawyers Guild into the context of this historical moment. So starting off with the National Lawyers Guild. The Guild, as I mentioned before, was formed in 1937. It was formed as an alternative to the American Bar Association for more progressive lawyers. Early members included communists, socialists, civil libertarians. It also attracted many who were shut out from the American Bar Association, particularly African Americans. Charles Hamilton Houston, Thurgood Marshall, and William Hastie, among other prominent African Americans, were members from its early years. In its early years, the Guild focused particularly on addressing economic hardships of lawyers, this was during the Great Depression, as well as providing legal services to underserved communities. But from its beginning, it was also caught up with questions about its connection to the Communist Party in the United States and overseas. In 1939, Earl Browder, the General Secretary of the Communist Party of the United States, described the Guild as a, quote, communist transmission belt. This then sparked a debate within the Guild about whether to denounce communism and expel communists from the group. When the majority of the members refused to do this, a number of prominent lawyers resigned from the Guild in protest. The Guild survived these early debates and divisions. And by the early post-war period, the Guild was doing pretty well with about 2,500 members. But the rising tide of anti-communism posed new challenges to the group. The Guild refused to require loyalty oaths of its members, as the American Bar Association did in 1948. And then in 1950, the House Committee on Un-American Activities, HUAC, issued a report that declared the Guild the, quote, legal bulwark of the Communist Party. The report asked the Attorney General to place the Guild on the official list of subversive organizations and to require the organization to register as a foreign agent. Such a move would mean that Guild members would be barred from employment in the federal government. Following HUAC's accusations, a wave of members resigned, and it became nearly impossible to recruit new members since young lawyers feared for their careers. And this was the Guild that Dickerson would become president of in 1951. I'm going to change gears a little bit now, but we will come back full circle back to Dickerson at the Guild. And what I want to talk about now is this idea of a division, a distinction, a divide between civil rights and civil liberties. And this is drawing on a book which will be coming out in early 2021, which is this history of civil rights in America. The book's theme is an effort to trace the usage of the term civil rights across American history. And I pick up this story in the mid-19th century and then carry it up through today. And there's a critical moment in the third chapter of the book where I look at the mid-20th century, the early post-World War II period, and look at this distinction between civil rights and civil liberties. So let me just give a little bit of backstory there to show how I arrived at that material. So the book does pick up in the mid-19th century, particularly with debate directly following the U.S. Civil War over civil rights laws. and the first moment in which the nation truly debated what civil rights meant. And I mean, in this case, not that people use the term civil rights, because the term certainly predated the Civil War, but the first time people actually looked at civil rights as something that was meaningfully something they wanted to debate about, and the first time people really argued that this was civil rights, and as importantly for my project, argue that something was not civil rights. One of the themes of my book are ways in which civil rights can serve exclusionary roles about trying to put things in the category and put things outside the category. So I began with 1866 to debate over what became known as the Civil Rights Act of 1866, where there was a first round of debates over civil rights. And these are the civil rights that Dylan was talking about, in terms of these are rights that were seen as so fundamental, so important, that to be denied these particular rights, and these rights included things like access to property and to contracting, ability to testify in court, to be denied these rights meant that someone was not fully a free person. And therefore, the reasoning went, these are the rights that could not be discriminated against. You could not be denied these on racial grounds. So this is the first version of civil rights in American history. This version was quickly contested because people tried to put additional rights into that category. There was big debates about political rights versus civil rights. Was a right to vote a civil right or not? Then there were debates about social rights. And one of the piece of legislation that came out of the debate about civil rights versus social rights was the 1875 Civil Rights Act, which included a national prohibition on racial discrimination in various public accommodations. This law was struck down in the famous civil rights cases of 1883. And among the different reasons the Supreme Court used to strike this down, one of the arguments they had was that basically Congress misnamed the rights. To say that access to public accommodations is a civil right, the court concluded, is a mislabeling, because they're not in fact civil rights, they're social rights. And therefore they couldn't be protected against the enforcement power of the 13th Amendment, was the way the reasoning went. Interestingly, in the period directly around and following that 1883 law, which struck down a federal prohibition on racial discrimination in public accommodations, you actually have a wave of state-level public accommodations laws, non-discrimination laws applied to public accommodations, most of which went under the label of civil rights. So at the very moment the court was insisting upon a narrow conception of civil rights, you actually see people around the country rallying around a broader conception, and most of these state-level laws are the product of activism by energized African-American communities. So you see some contestation about what actually it meant to be civil rights. For purposes of today, when we're looking at what happened by the time you get to 20th century, the important point is that by the time you get to the turn of the 20th century, by the time you get to the first few decades of the 20th century, there's no real consensus about the meaning of civil rights. The term sometimes would be used to reference specifically public accommodation laws. Sometimes it would be used to reference some fundamentality of a right, meaning a property right or a contracting right. Oftentimes it is just used in a very generic and amorphous sense, and no one is really fighting battles about what was or was not a civil right. All this began to change in the 1940s. This is when the term civil rights was reborn, I argue, and it was at this time that we see something approaching the modern meaning of the term that we're familiar with today. The emergence of this modern understanding of civil rights in the middle of the 20th century was a product of a remarkable and little known, even among scholars of this period, moment of confusion and fortuity. The development can be traced quite precisely to 1947 and the release of the report of Truman's Presidential Committee on Civil Rights. This is the first time that people began to use the term civil rights as a synonym for rights for African Americans. Truman had created this commission in 1946 in response to a series of racial atrocities in the South. He wanted a commission that he said would offer reform proposals to address America's explosive and internationally embarrassing racial situation, and also to take some heat off his administration to take some action. You know, you don't know what to do, you create a commission. It's pretty standard operating procedure for a president. The question for his advisors as they put together this commission was, what were they going to name it? They didn't want a title that was too narrow, nothing too specific. Again, this is an idea of deflecting some pressure on the administration. They did kick around the idea of labeling a Civil Liberties Commission, but that idea was nixed because they felt like the term was too radical. And a lot of this had to do with the fact that the ACLU had already embraced the term civil liberties, and the idea that civil liberties is somehow connected with political radicalism, which is the last thing they wanted to have attached to this. Truman's advisors eventually settled on the term civil rights because, in the words of one of his advisors, it was slightly fresh. In 1946, the term actually came with remarkably little baggage. The commission struggled to define its role. Its members wrote letters to the lawyers in the Civil Rights Division of the Justice Department asking for guidance. The lawyers in the Civil Rights Division wrote back, explained that they didn't really have much of an idea what civil rights meant. The commission wrote letters to a lot of groups asking for their thoughts on what a Civil Rights Commission might do. And they got back lots of ideas. I mean, basically everyone who did anything that they could conceivably claim as a rights issue said, yeah, we're fighting for civil rights too. The committee finally settled on a report that focused almost exclusively on issues related to the place of African Americans in society. The report was subsequently widely reported on and reprinted. Truman put together a legislative package based on its recommendations, and this was called a civil rights program. It failed, the program failed, the legislation never went through, but the term stuck. And what had been called the Negro problem, or sometimes the American dilemma, now became transformed into a civil rights issue. At the same time, as civil rights is becoming synonymous with the rights of African Americans, they also have a movement to define what civil liberties meant. And the definition of civil liberties was very much understood in juxtaposition to this emergent concept of civil rights. The President's Commission report, focused primarily as it was on the issue of race in America, largely bypassed the other pressing minority issue of the day, which is the right of political dissenters. It included in its 180 pages, I believe, just a 6-page discussion on the right to freedom of conscience and expression, which it prefaced with a disclaimer saying that the committee did only limited research on this topic, due in part to, quote, the conviction that this right is relatively secure. That this seminal declaration of civil rights focused almost exclusively on the problem of racial discrimination did play a critical role in shaping the kinds of issues that would be associated with civil rights going forward. Central to the emergence of civil rights as a distinct concept was its juxtaposition to civil liberties, a term that prior to this moment, no one had really thought to distinguish from civil rights. The terms were used largely interchangeably prior to the late 1940s. The release of the report sparked a new development in American political and legal discourse in which commentators, scholars, and politicians began to distinguish the two labels. And let me just give you one of the more prominent examples. Harry Truman gave an address, the first president to give an address in person before the NAACP in 1947, and where he said the following. He said, "We cannot be content with a civil liberties program which emphasizes only the needs of protection of the people against the possibility of tyranny by the government. The extension of civil rights today means not protection of the people against the government, but protection of the people by the government." So it's important to note that the moves he's making here is not only a distinction of civil rights from civil liberties as two different ideas, but also it is also a defense of a more robust government presence, that those people who are concerned with too much government authority, right, were basically being pushed aside as defending civil liberties, and civil rights actually demanded more government activity. And he was calling, the civil rights program he was calling for actually was a significant expansion in terms of federal responsibility, federal authority over the states. The reborn idea of civil rights and the concurrent distinction from civil liberties offered a language that helped Cold War liberals articulate and pursue their agenda. They pushed aside the civil libertarian position that saw the expansion of federal government power as an inherent threat to basic freedoms. True to their New Deal roots, the Cold War liberals believed that the needed reform generally should come from improving and expanding government regulation. What was needed, they argued, was not a civil rights mindset, but rather a civil liberties mindset. One more example in terms of how this was used, one of the most prominent figures of the day, he really pushed this distinction, was Arthur Schlesinger, who in his 1949 Cold War manifesto, or Manifesto of Cold War Liberalism, called The Vital Center, he explained this distinction between civil rights and civil liberties. Civil rights, he said, refers to racial and religious discrimination, and then he described the federal civil rights legislation, some of which is still on the books, as well as the President's Committee on Civil Rights, saying this is civil rights. Civil liberties, by contrast, refers to freedoms of conscience and expression. He went on to assert that fighting for civil rights is a fight against the sin of racial pride, and he described it as one of the most basic challenges to the American conscience. And he says it's fatal not to maintain an unrelenting attack on all forms of racial discrimination. But then he contrasted it. He then used it as a pivot to then say, but civil liberties we need to approach differently. To understand how to protect civil liberties, it's not an unrelenting attack, but it requires, he said, a considered redefinition in terms of the threats of a free society presented by fascism and communism. Although this was far from an endorsement of the witch hunts being led by the HUAC in the coming years by Joseph McCarthy, Schlesinger offered a standard liberal anti-communist argument for recognizing the need for limits on civil liberties in order to protect national security interests. So now I want to think about how different groups were affected by this emergent distinction. And again, this is a linguistic difference, but it's a linguistic difference that I believe reflected and amplified changes that were going on in the politics of the day. For some people, this was an opportunity. It was an opportunity both because this term civil rights was resonating in ways that it hadn't before. So the term civil rights itself was a powerful vehicle on which activists could then attach their causes. And that's one reason why eventually when the Black freedom struggle exploded in the 50s and 60s, people did start describing it as the civil rights movement or the civil rights revolution. But in addition to this, the distinction between civil liberties and civil rights also provided leverage for certain groups. The assumption behind this nascent civil rights, civil liberties divide, that the cause of racial equality could be advanced alongside only qualified protections for protest and expression, aligned relatively comfortably with the beliefs of influential racial justice advocates of the day. The anti-communist fervor of the early Cold War created new and powerful incentives for racial justice activists to separate themselves from political radicals. In 1947, the NAACP Executive Secretary Walter White was able to get FBI Director J. Edgar Hoover to formally endorse the NAACP's loyalty. The NAACP publicly expelled communists from their organization in 1950. Thurgood Marshall resigned from the National Lawyers Guild after the organization criticized a federal judge for his handling of a 1949 sedition trial of communists. In interviews, Thurgood Marshall would sometimes brag that he was more responsible than anyone else in the NAACP for pushing the communists out of the organization. And in this way, the emergent civil rights, civil liberties divide offered a tool for understanding and navigating the political landscape of the 1940s. But some people felt that there's cost to this as well, that necessarily where there might be some advantage to it, there are also some downsides. So in the late 1940s, 1950s, as liberals defined and defended their civil rights program, some leftists warned of the cost of this emerging distinction between civil rights and civil liberties. As the editors of the left-leaning Nation magazine in 1950 lamented, within the past 3 years, a distinction has developed between civil rights and civil liberties that clearly reflects a tendency to reject the moral commitment to preserve our freedom, which is part of the American heritage. They then asked the key question: what if the price which government demands for the affirmative protection of civil rights is acquiescence to the curtailment of civil liberties? The person behind the Nation's warning was contributing editor Carey McWilliams, a lawyer, labor activist, and author who aggressively opposed both anti-communism and racial discrimination. McWilliams condemned McCarthyism in a 1950 book called The Witch Hunt, warning of the danger inherent in the distinction between civil rights and civil liberties. He criticized the President's Committee on Civil Rights for failing to denounce the President's loyalty program, and he said by ignoring the civil rights guaranteed in the First Amendment, the committee was diverting public attention from the real threat to civil rights. The hopeful expectation about a new deal for racial minorities was being encouraged as a cover for a campaign to coerce conformity on economic and political issues. Leftists who saw this new effort to divide up rights claims for what it was, an attempt by Cold War liberals to locate a vocabulary that better defined and defended their particular array of policy preferences, in the process leaving radicals even more vulnerable to the anti-communist fervor that was taking over the country. The further left one was on a political spectrum, the more one had to lose from the civil rights, civil liberties divide. It detached a liberal cause that was growing in support, meaning legal rights for African Americans, from one that was under fire, speech and criminal procedure protections for leftists. As mainstream political discourse increasingly embraced this newly conceived distinction between civil rights and civil liberties, leftists pushed back, cautioning against distinguishing what they insisted was indivisible. Now we're going to come back to Earl Dickerson and National Lawyers Guild. Dickerson's selection as president of the National Lawyers Guild was yet another in a long line of his breakthrough achievements. He was not only the organization's first Black president, he was the first African American to head any predominantly white bar association. During his time at the helm of the National Lawyers Guild, he sought to pursue both racial justice reform and defend civil liberties that were increasingly under pressure by anti-communist fervor. Dickerson's role within the National Lawyers Guild was made more difficult, more difficult in some ways to fully pursue a racial justice agenda, because at his time the Lawyers Guild was working to protect itself, to basically defend its survival, and is in many ways weakened during this period. The main attack on the Lawyers Guild came from Attorney General Herbert Brownell, who in 1953 announced his intention to place the Guild on the list of subversive organizations. Brownell said that he had looked with particular care at the charges against the Guild because in its early years, he said, it had members who were well-known and completely loyal citizens, including many colored members who had gone there because they were blocked from the American Bar Association. But he concluded by 1946, the leadership of the Guild was in the hands of card-carrying communists and fellow travelers. Dickerson issued a statement refuting the Attorney General's charges and saying the Guild would dedicate itself to fighting against this designation. The Guild, his statement read, had been committed to serving the best interests of the lawyers and people of America. The Guild quickly filed a notice contesting the Attorney General's intention to list the group as a subversive organization, and ultimately this led to several years of litigation in which the Guild was never actually listed, and then by 1958, the Justice Department backed down and said that they were not going to list it. Dickerson's tactics defending the Guild were interesting, though. His primary move was to defend the Guild against charges of being under the influence of communists, but also challenging the Communist Party line. In an interview, he praised progress Black Americans had made under, quote, our system of government, but he challenged communist aggression, and he actually defended the U.S. position in the Korean War. At the same time, he condemned what he described as the whittling away of our Constitution, indicating both issues of loyalty as well as racial discrimination. So just to wrap this up, as he did so often throughout his life, Dickerson charted his own course through the swirling currents of the politics of the civil rights, civil liberties divide. Whereas many other leading African-American social justice activists retreated on civil liberties in order to strengthen their defense of civil rights, Dickerson refused to back down on either ground. There are no easy solutions available here. Dickerson's decision had its costs. Although the Guild did continue to press racial justice issues, and it would eventually become an important player in the civil rights movement in the 1960s, most of the time, the group's time and resources during his time leading the organization was focused on civil liberties, not civil rights. Yet he insisted that the fundamental values of the Constitution were indivisible, and that one could not achieve civil rights without civil liberties, just as one could not achieve civil liberties without civil rights. And I'll conclude with Dickerson's own words I believe resonate today as they did in 1952 when he spoke them. The aim of the opposition, he said, is to remove from the democratic struggle those who are willing to fight for it. Thank you.
Thank you so much, Professors Penningroth and Professor Schmidt. We have a number of questions. The first is really both of you have, you're speaking about dichotomies, right? So the rights of everyday use versus civil rights on the one hand, and the civil rights, civil liberties divide. Could you speak about how to think of the lawyers involved in this different conception? So how do we think of the lawyer Earl Dickerson? He did both, things like the rights of everyday use, and then he also worked at the firm and worked for Supreme Life. He embraced the new concept of civil rights. He also worked for civil liberties within the National Lawyers Guild. So how should we think about these different conceptions? And if they are changing over time, you can talk about that as well.
Dylan, you want to start with that? So I'll get the ball rolling, and Dylan, you jump on in. So one thing that's definitely clear is that in my research on it, the book is largely on civil rights, but to understand civil rights in this period, you need to also understand the juxtaposition of civil liberties. The self-conception of most of these lawyers who are dealing with these categories was sometimes quite self-conscious, in that sometimes the terms were meaningful to them. Sometimes they'd actually use the terms to help make sense of what was going on in the world around them. But more often than not, the terms fell into the background, and I think this is where it really taps into the way Dylan is approaching the topic. The terms pushed in the background, and people are just dealing with day-to-day struggles about how to actually fight against certain situations. So I don't see Earl Dickerson sort of saying, oh, I wish I could do more civil rights instead of civil liberties. But again, this was the idea that he had these two agendas that he could put forth. He could describe them this way when it was useful. The language is only useful when the categories are meaningful for some reason. But I would say oftentimes the situations of people who are actually on the ground or people who are fighting these issues the categories just are not necessarily relevant to them in day-to-day situations. They pop up here and there, but oftentimes they then fold into the background.
I don't have a ton to add to that. I mean, Chris and I have been talking for years about this distinction between civil rights as a term versus as a concept. And I think both of us are trying to do both. I suppose my work leans more toward the concept, precisely because so many of the people who I study, they don't explicitly use one term or another, whether civil rights, civil liberties, or anything else. It's only the activists and the people who are see themselves as advocating in a particular genre that use those terms. Most everybody else just talks about getting a deed.
Thank you. And there's a question that came in for Professor Penningroth. It's a legal historical research methods question. The question is, how did you identify that the lawsuits involved Black people, Black lawyers? Is race in the records that you looked at? Can you tell?
No, you can't tell. Not from the records themselves. They almost never list race. Sometimes they list it in divorce cases, but usually not. What I ended up doing was creating a database from those county circuit court suits, and then coding them using the online database ancestry.com. The hit rate, that is to say, the rate at which I was able to, with some degree of confidence, match a person to the census was around half, about 50%. I can get a hit on one party or the other. And so the statistics I gave, I only talked about the ones where I identified a plaintiff. So there are other cases where I coded and I only had the defendant. The story of leaving race out is sort of a whole other thing itself, like race marking in records. And it's a story that takes place in one country, one post-slavery society after another. Rebecca Scott has written about this, Brazilian historians. That kind of erasing is, both political and in many ways an act of violence. In our country, it has a particular meaning. But as far as your question goes, method, it's just a real pain in the rear.
If people have questions, please feel free to ask. I can ask a follow-up question to the first question, which is, your response was, the terms were used, concepts were used as they were pertinent, depending on what was going on and what the fight was about. But I was wondering if there were differences in status and prestige, depending on who was using what concept and at what time they were using the concepts. Even within the legal profession itself, where there sort of prestige status issues. You talked about the ACLU. What was sort of going on within the profession itself?
Yeah, that's such a good question. So I hadn't really thought of it as a prestige issue, particularly if you're looking at the legal community. But yeah, I could see some of that playing some work. So one thing I definitely noticed is that during the middle part of the 20th century, the term civil rights was very much a term that at that moment was tied up with law and lawyers. So there was actually an elitism simply to using a term like civil rights and civil liberties. Right. If you guys, this is a fascinating part that came out in the chapter of my book, which focuses on the civil rights movement itself. If you look at the names of the organizations that were grassroots organizations during the movement years, almost none of them mentioned civil rights. They actually rarely mentioned rights, but almost none of them mentioned civil rights. The groups that actually defined themselves as civil rights organizations were very much top down. They're oftentimes white dominated. They're oftentimes very legalistic, and lawyers played a major role in them. So the term has come to take on these broader connotations because of the struggle itself and because of the efforts, as Dylan alluded to, of this scholarly movement to a sort of more robust law and conception of civil rights. But at the time itself, civil rights was actually oftentimes held at arm's length. And it was oftentimes used to juxtapose people who were struggling on the issue from one direction, oftentimes from sort of more of a grassroots approach versus top down. For example, the subject matter of the first book I wrote on the sit-ins, The sit-in protesters would often say, what we're doing is not civil rights. Because in their mind, civil rights meant what Thurgood Marshall is doing. What Thurgood Marshall is doing was fighting the good fight, but doing it in a very different way. So they said, what we need is something other than a civil rights approach, which is striking to our modern ears because the sit-in protests were an iconic moment of civil rights protests. They themselves had other language. They talked a lot about freedom and justice and these more robust, I think, meaty terms that meant more to them on the ground. So in terms of, again, I hadn't thought so much as prestige, but more of the perspective of the participant in the struggle and at what entry point they had would partly indicate their attitude towards a rights kind of term like civil rights.
Yeah, I really appreciate that question about prestige because it gets at, my story goes back to, before the Civil War. And of course, one big storyline is the expulsion of African-American lawyers from the legal profession in much of the South. Most of the lawyers who handled civil matters for African-Americans were white people. Many of them were ex-Confederates, like they served in the Confederate Army. They're basically white supremacists. Obviously, part of the reason that they're willing to handle cases for African-Americans is because they're not claiming anything that threatens the edifice of white supremacy. And yet, some of the cases that these guys handle for African-Americans, they're about what you could describe as labor rights. Like it's kind of like dangerously close, at least in my mind, to the kind of stuff that the long civil rights movement historians are talking about. In particular, I'm thinking of a case that James Eastland handled on behalf of a group of Mississippi tenant farmers against an out-of-state corporation which had cheated them out of their pay. So that kind of, and they would use words that came very close to constitutional language, even though they're not bringing constitutional arguments. So it could be unpredictable.
Thank you so much. If there are no other questions, we can break now for, we have a short break until 3:15, rather. So we'll see you at 3:15. Thank you so much, Professor Schmidt and Penningroth. Appreciate it.
Thank you.